Abbey National Building Society v. Cann 1991. Mrs. Cann had been living in rented accommodation and was offered the opportunity to purchase the freehold of the property at a substantial undervalue by virtue of her status as a protected tenant. Mrs. Cann could not afford to purchase the house, but her son offered to purchase it on her behalf. He took out a mortgage on the property and promised his mother she could stay there rent-free and would always have a roof over her head. The property was duly conveyed into their joint names and they both lived in the property along with Mrs. Cann's second husband. Subsequently, the house was sold and another property was purchased in the sole name of the son. The purchase price being met partly from the proceeds of sale and partly by mortgage taken out by the son. The three of them lived in the property until the son left to live with a woman he subsequently married. The son found it difficult to pay for the two homes and therefore told Mr. and Mrs. Cann that he would need to sell the house and buy them something smaller. They found a suitable property and the son took out a mortgage with the Abbey National Building Society to pay for the new property. He then defaulted on the payments and the bank sought possession. Mrs. Cann sought to establish an overriding interest based on her contribution to the original purchase in the form of the reduced purchase price through her status as protected tenant and the son's assurance that she would always have a roof over her head coupled with actual occupation. On the date of completion, Mrs. Cann was on holiday in the Netherlands. But her son and husband had started moving in the furniture and her carpet fitters had gone into the property 35 minutes before completion had taken place. The relevant time for determining occupation for the purposes of S.701g was the date of completion of the transaction rather than the date of registration. The preliminary acts of moving in were not sufficient to constitute actual occupation.